Good afternoon, everyone. My name is David Friedman. I'm counsel Wagner Sidlowski, and I'm assisting my colleague Peter Neufeld in co-chairing this Lunch and Learn series on will challenges. The topic that we'll be discussing today is the trial of a will challenge. Please note that this is the last of the seminars in this series. However, all of the previous seminars have been recorded. And if you go to our website, you should be able to click through the links to find all of the seminars and watch them online. And I believe that there are some handouts as well that are available. A blog was prepared by Peter Neufeld and Greg Sidlowski in advance of today's seminar. And I believe that there are two papers that are available. And that the download link, the download link will be put into the chat bar, and you can download the papers there. Just a couple of things of requests. If you would please keep your microphones off, I would be grateful. Turn your microphone on, obviously, if you're going to ask a question, but I would ask that you turn it off thereafter. I'd also like you to note that this seminar is being recorded. We have two presenters today. Greg Sidlowski is the managing partner of Wagner Sidlowski and is certified by the Law Society of Ontario as a specialist in civil litigation. He'll be joined by Peter Neufeld, partner at Wagner Sidlowski and one of the co-chairs of this event. Greg and Peter both practice in estate and commercial litigation at Wagner Sidlowski. I'd like to thank our sponsors, B'nai B'rith, Centra Trust, Social Wealth Management, Torque and Mains, PD, and BMO Trust and Estates. This event is complimentary because of their support. What I'd like to do now is invite our speakers to start to present, and our first presenter is Gregory Sidlowski. Greg, please.
Thank you, David, and thank you everyone for attending. I'll be discussing trial preparation generally, and then Peter Neufeld will focus on what a will drafting lawyer in particular can anticipate when testifying at trial. Now, addressing all of the topic points and preparation that goes into conducting a trial would take days. In fact, it would take an intensive trial practice course. So what I did was prepared a detailed collection of tips covering all aspects of a trial, including the lead up to it. And Maddie has shared that document in the chat. The trial is literally the culmination of all of the work that goes into pursuing or defending a claim in our justice system. It is not just the main event, it is the be-all and end-all of the case. And that is especially true given the appellate court's deference to any and all findings made at trial. So everything will turn on the evidence that goes in at trial and the issues that are argued. A lack of preparation, a lack of organization, the thought that you can just wing it will be readily apparent to the judge, your client, and opposing counsel. And it risks turning a strong case into a loser. So how do you prepare going into a trial to ensure that your client has the best shot at a successful outcome? The answer is only through hard work. And that work starts long before trial. You need to approach trial prep in a methodical and comprehensive manner. And when I say long before trial, I actually mean that. In my trial preparation tips document that has been shared on the chat, I identify a number of topics that need to be addressed many months before the commencement of the trial. The first step is ensuring that the pleadings reflect how you want to pursue your case. Cases evolve during the litigation process, sometimes very significantly. And you need to make sure that your pleadings reflect the case that you actually intend to lead at trial. If the pleading needs amendment, then you need to address it, perhaps in a motion, perhaps at the pretrial, or possibly at the commencement of trial itself, which happens all of the time. You also need to go back to ensure that your undertakings are answered. You need to review your refusals, make sure that your refusals are not going to prevent you from leading necessary evidence. If so, you need to address it and fast. You also need to ensure that your productions are complete, that the transcripts are available, because last-minute disclosure risks adjournments, and those adjournments could set your client back a year or more and tens of thousands of dollars in costs. Now then there's the substantive trial prep, closer to trial. And the first thing I refer to in the trial preparation tips is the trial memo. And this is a comprehensive document that will serve as your complete guide to proving your case. It will start off by setting out the theme of your case, break down the claim into the causes of action that you will be pursuing or responding to, set out the legal elements of the causes of action that need to be proven and the case law citations that you will rely on. It should list the facts needed to prove each cause of action, identify which witnesses you will be relying on to get those facts. It should include the references from the transcript that you will be relying on for read-ins or in cross-examination. And it should reference the key documents that need to be entered as exhibits, as well as notes to address any issues with getting those documents marked as exhibits. Then there are the various notices, requests, summonses that need to be prepared and served prior to trial. And those include the Evidence Act notices, requests to admit under Rule 5102, summonses to witness, anyone that you do not have direct control over, i.e. who is not your client or a paid expert. Definitely you want to have a summons served on them in advance to ensure their attendance. And if they don't attend, to justify perhaps an adjournment or even the court's assistance in securing their attendance. And all of these need to be dealt with in accordance with the deadlines set by the rules of civil procedure. Then there's the Book of Documents. In many ways, the Book of Documents will chart the course for the evidence of your main witness, as you take the witness and the court through the documents that will help prove your case. You need to know whether there will be agreement on the documents being marked as exhibits, and you need to know that in advance. So you can advise the judge at the commencement of trial whether the Book of Documents can be marked as an exhibit, which means that all of the documents can be relied on for the truth of their contents, or whether you're going to have to establish a foundation for the documents as you examine witnesses and then gain their admissibility individually. Then we have the witness preparation, which is always challenging. Usually the weakest part of your case, and certainly the most risky, is the evidence of your own client. Your witnesses need to be ready to address all of the facts necessary to prove their case. But at the same time, they need to show the judge that they are genuine, believable, and hopefully deserving of the court's assistance. If the court does not like your client, then you're in trouble. But how to ensure your witnesses achieve those goals requires judgment and experience. Overly scripting a witness is a recipe for disaster. It may be obvious to the court. It will detract from the sincerity of the witness, but it also risks the witness falling apart when there are interruptions or objections that might take the witness away from their rehearsed script. So instead, you need to work very hard to make it appear that you are not working hard, and to get your witness's evidence out in a more organic way, which just appears as though your witness is telling their story. And the lawyer is just there to guide them and to prompt them to help them get their story out. That's easier said than done, but that is definitely the goal. Now, at the start of trial, there is that very first opportunity when the judge asks you, are there any preliminary housekeeping matters that we need to deal with? And there always are. These include amendments to the pleadings. It's your opportunity to pursue that amendment. It'll also be when you deal with the book of documents. The trial judge is going to ask you, when you hand up that book, what he or she can make of the documents. Can they look at them? Can they treat them as though the contents are admitted for their truth? Those are questions that you really have to have clarified right at the very start. And if you're on top of things, you'll also have a case brief, because the judge wants to have it as soon as possible, and they want to know what the general legal principles are as they go along. Then you come to the opening statement, and it really needs to be concise. And of course, you cannot argue your case in the opening, and you cannot promise more than what you can expect to deliver. But the opening is key in order to provide the court with context as to what the theme of your case is, what witnesses will be called, what you expect their evidence will be, as well as basic information on the applicable legal principles. And it is this context at the start that is essential for the trial judge to understand what the case is about and to make sense of what they are hearing from the witnesses as the evidence goes in. And then you call your case. It's usually appropriate to start with your client as the first witness. They generally have the most to say. And you've already prepped them. You guide them through their evidence. And then comes the cross. In your preparation of your witness, you have to prepare them for cross-examination. You need to ensure that your client knows and understands the areas that are likely going to be covered in cross. You need to ensure that they know the weak spots in their evidence that the opposing lawyer will focus on and how to best address them. You also need to ensure that your client understands the importance of keeping their cool, not arguing with opposing counsel, and not evading questions. But as much as you might try, you cannot change your witness's personality. And all the prep in the world will not stand up to a good cross-examination and a witness who has, well, let's just say perhaps a short fuse. But that's why your client needs to prepare by knowing the documents, knowing their transcript evidence, and knowing any affidavit evidence that they filed previously. Then they can just be ready to answer the questions as best they can. Now, when you are cross-examining a witness, the biggest mistake is not asking leading questions. Giving up the control that leading questions allow for risks damaging your case and misses the opportunity to get admissions and demonstrate the weaknesses of the witness's evidence. And you have to really beware of questions that you do not know the answer to. Generally, everyone's advice is don't ask them unless you are certain that you can work with whatever answer the witness gives you. You need to rely on the transcripts to prepare your cross-examination and use the evidence from that transcript to form the basis of your questions. That way, you will always be ready to impeach or to draw out inconsistencies in the evidence. If there is no transcript, then you have to rely on the documents to keep the witness's evidence in line. You also have to be aware of the rule in Brown and Dunn. which essentially means if you represent a defendant and you intend to lead evidence in the defendant's case that is different from the evidence led in the plaintiff's case, well, then you have to put that difference to the plaintiff in order to give them an opportunity to answer it. So you need to ask yourself, going into a cross-examination, what do you need to accomplish? And when you've done that, or when you know you can't, then you sit down. You start the cross-examination getting the admissions that are not contentious. You leave the contentious questions until after you've obtained everything you think you can get by being nice. But never be rude, never be hyper-aggressive. The judge will not be impressed and it will backfire on you as the lawyer. Be direct. Insist on getting responsive answers to your questions. Don't let the witness evade. Don't settle for non-answers. And the best way to do that is to ensure you have a plan. Do not wing a cross-examination. Now, I touched on impeachment just a moment ago, and I deal with it in a little bit more detail in the trial preparation tips. Impeachment takes practice, but you should also explain the concept to your client so that they understand what is going on when it is happening to them. If the cross-examination is based on earlier transcript evidence, then any evidence the witness gives at trial that is different from the earlier transcript evidence or different from earlier affidavits, it opens them up to being impeached, which is basically just a fancy word for contradicted. And there are specific methods for impeachment, but generally it comes down to getting the witness to recommit to what they said in their testimony at trial, getting the witness to acknowledge the circumstances of the prior inconsistent statement. For example, he or she was examined for discovery, they were under oath, they tried to answer all the questions accurately and honestly, their memory was better back when they were examined or back when they affirmed their affidavit. And then confronting the witness with the inconsistent statement from the transcript or affidavit. And you need to decide what you want to use the inconsistent statement for. You might want to get the witness to agree that the earlier statement was the correct statement, or you might just want to play up the discrepancy and use it to argue that the witness is not credible. Then there may be re-examination. You have to know when to re-examine and how. You cannot lead your witness. At best, you can repeat what the witness said in cross and then ask open-ended questions to seek clarification. That limitation on how you can conduct re-examination means you need to explain to your witnesses in advance that if you ask them questions after their cross-examination, there's a reason for it. It's because he or she said something in cross that you think needs to be clarified or corrected. So if you stand up to ask questions in re-examination, your witness should be asking themselves, what am I being asked to clarify? Then there might be a requirement for rebuttal evidence. If evidence arises during the defendant's case that you did not address in the plaintiff's case, then you will likely be permitted to call rebuttal evidence, but it is not a certainty. You need to be ready with case law to show that it is appropriate to call that evidence, but it will generally be permitted, at least in civil cases. And then you have the closing. You have your book of authorities ready. Many judges will ask for a closing factum. If the judge asks for one, then you have to provide it, even if that means staying up late into the night during the trial to prepare it. My advice is have the outline of a factum ready. It can very closely resemble your trial memo, or it will very closely resemble your closing argument. The closing needs to come back to your theme of the case. and how the facts support the cause of action pleaded and call for the relief sought. You need to review the material facts that you are asking the judge to find. Review the law, take the court through the case law, and apply the law to the facts of your case. Tell the court what you are asking the court to do, and be prepared for questions. The closing is the judge's only real opportunity to probe and to ask questions about your case. They're not supposed to do that during the trial. They're not supposed to put questions to your witnesses. So this is their opportunity to really shed some light on what's going through the trial judge's mind and any concerns that they have, and give you an opportunity to address those concerns. And then after closing, you wait and you hope for the best. So Peter, why don't you now take us through some of the tips and advice that are more specific to will drafting lawyers who are giving evidence, and then we can take some questions.
Sure. Thanks, Greg, for that. Really helpful. I mean, if you don't know already, Greg is certainly no stranger to trying cases, so his input's really helpful here. The one thing that I've personally taken away from Greg working with him on trials is goes back to the trial memo that Greg has referred to. You know, that really is your Bible. It's not something you need to give to anyone else. It's your own. It's a living document that you will update throughout the trial. And it's going to help you with your referencing, all the other documents that you've had to prepare in advance. It's going to significantly help you with the closing submissions. So, I would say if there's really one takeaway from this seminar is, always ensure that you're doing a comprehensive trial memo prior to trying a case, and getting it done as starting it as early as possible. So like Greg said, I want to focus on, what is a will drafting lawyer to expect from a trial? I suspect that there's a lot of people in the audience that prepare wills and maybe they want to know, okay, well, I have this overview of what the process is going to be. Now, where do I fit into this? It's not going to be a surprise by the time you get to a trial what sort of evidence you're going to have to give. You're a witness here. This is assuming that you haven't been added as a party. So really, you're going to be giving evidence about the circumstances surrounding the preparation of the will that you did, whether you conducted an assessment of the deceased's capacity at the time that you were getting instructions from them. And again, that capacity would relate to their ability to, for you to take instructions from them, but also their ability to prepare a will themselves, as well as, any steps that you took to ensure that deceased was not subject to undue influence. If there are allegations of undue influence, they're going to ask you about your records, the notes that you took contemporaneous with the preparation of those wills and getting instructions. That is going to be expected. You'll know that because there is a good chance that you have already been examined for discovery prior to this going to a trial. As we've spoken in prior seminars, there are often orders for productions from the drafting lawyer, as well as orders for leave to examine that lawyer prior to a hearing of the application. And so it's often that you've already been in a boardroom or through Zoom, you've already given a lot of the evidence and you've already been cross-examined in some form prior to the actual trial. But one thing I mentioned was applications, right? These are typically applications that we deal with, not actions. So how did we get to a trial? Again, that was addressed in a previous seminar, but briefly, it can really be one of two ways. Often it's either converted from an application into an action because these are issues that should be tried in an actual trial, or a court under Rule 75 may direct that certain issues in contention need to be tried as opposed to dealt with by way of application. Because of that, you've had this converted into an action, or you've had certain issues directed to be tried. The next step is going to be a pretrial. That's assuming you've already done your mediation, if it was mandatory or ordered, and you've already finished the discovery process. For a pretrial, it's not likely that the drafting lawyer is going to be attending that pretrial if they're a witness. And I say that because it's typically just the parties to the litigation who will be attending as a pretrial. But it's important to know what may be ordered, what is eventually ordered, and how that impacts your evidence. Greg touched on this a little bit. There may be requests to admit. So one party will request that the other side admit certain facts that are currently in dispute. They will then have a certain amount of time to respond to that. And they may be prejudiced to the extent that they don't respond within that timeline. There are also agreed statement of facts, which is a more conciliatory approach to put to the judge to say these are not issues in dispute. And that's critical for, or it could be critical for a drafting a lawyer. If there are issues in dispute that were in dispute in the pleadings that impacted the scope of the lawyer's evidence to give at trial. It may be that now, after we've done the discovery process, certain facts are no longer in dispute that drafting lawyer would have had to give evidence on. And if they're not in dispute, then arguably it's something that you shouldn't be giving evidence on. Now, it's not your role to object to that if you're asked these questions. That's going to be your lawyer's role, or it's going to be the lawyer propounding the will to object to those. But it's something to keep in mind to know what it's good to review the agreed statement of facts, any requests to admit and responses, as well as the pleadings, of course, just so you're aware as to what issues are in dispute and what issues are not, because that's really going to inform you on what evidence you're likely going to have to give. Summons to witness. You will possibly be summoned through a summons to witness to attend the trial. They will specify the date that you will have to give evidence in court. They will provide you with a possibly insulting but very modest stipend in accordance with Tariff A of the rules. That's what is required by them. Once you are served with that summons, you have to show up. I'm sure that your Law Pro counsel, who will have been representing you at this point, will already tell you this. And given that you're a lawyer, it's not something that I think will be much of an issue for you to attend, but you need to attend. If you don't, a court could go as severe as order that you be arrested and detained. So of course it's something that you need to do. Oftentimes though, a summons won't be necessary when we're dealing with witnesses such as a lawyer. It may be that Law Pro counsel just confirms the date that the lawyer will be coming to trial to give oral evidence. But what's the actual process for the trial? Now, Greg's mentioned this. We've got the examination in chief, the cross-examination, and re-examination. So what does that mean for the will drafting lawyer? Well, you can expect that the lawyer for the propounder of the will is going to try and make you look as good and professional as possible and try to make it show that you did everything you were supposed to do and you took perfect notes. And to the extent you didn't take perfect notes, there's a very valid and justifiable reason for that. They're going to ask you non-leading questions. That's their obligation. If they ask you leading questions, that will likely be objected to by the challenger of the will or the challenger's lawyer. And so you can expect that you'll be asked questions about, again, whether the deceased had capacity, what you did to ensure that the deceased had capacity to sign a will, whether the deceased understood their assets, what you did to ensure that they did understand those assets, to ensure that they understood the terms of the will, notes if they, evidence about whether they provided you with an explanation for significant deviations from a prior will that they had prepared. And all of this, again, really goes back to that Banks and Goodfellow test that we've referenced quite a few times. in the series. And that's the test to determine the capacity or whether someone lacked testamentary capacity to prepare a will, right? That is the onus that the challenger of the will is going to have to meet. And so the questions that they ask at trial are going to be informed by that. And on the other side, the propounder of the will, who's conducting the examination of it in chief, is also going to be informed by that test to try and rebut the challenger's argument that the will is invalid for lack of testamentary capacity. To the extent that undue influence is being alleged, the lawyer might ask questions. Conducting the examination might ask the drafting lawyer about the circumstances under which the will was signed, what was discussed about the intentions of the testator, the reasons for the dispositions in the will, and specifically whatever steps the drafting lawyer took to determine if anyone was pressuring the testator concerning the terms of the will, whether the drafting lawyer permitted other individuals to attend the meeting in which the testator gave the lawyer instructions, or whether they insisted that any other individuals remain outside in the lobby, questions to that effect. The goal of the propounder's lawyer will be to explain the circumstances under which the will was prepared and to persuade the judge, in this case, that no undue influence has existed. At the end of your examination in chief, you might feel that you've done a pretty good job, and you might feel good about yourself because you've been able to give a nice explanation as to, all the reasonable steps you took, and to the extent that there were gaps in some of your normal practice, you provided a good explanation for that. That feeling may end quickly once cross-examination starts. Cross-examination is often a much more intense and much more unpleasant experience for the will drafting lawyer, and I don't think there's any question as to why that is. The elephant in the room is that the challenger is often trying to attack the drafting lawyer's actions that they did or didn't do when taking instructions and when preparing that will. They are going to attack the notes that the drafting lawyer prepared. They are going to allege that the drafting lawyer didn't take the time to properly assess the deceased's capacity. And, in my experience, a lot of the time, one of the more significant types of records that are missing from a drafting lawyer's records who prepared a will is the test, is the assessment of the deceased's capacity at the time that they took those instructions. And so you can expect that you're going to be attacked on that because you would have produced your file already. And there is quite often missing records or an absence of records even regarding the deceased's capacity. The challenger or the challenger's lawyer is going to ask leading questions. They are permitted to do that in a cross-examination. They're going to do this to try and secure admissions that support their arguments that the deceased lacked testamentary capacity and was unduly influenced. They're going to put words in your mouth, or at least try to. They want to get you to agree with the questions that were asked. And they're going to use other documentary or other witnesses' evidence available to challenge your credibility and to challenge the observations that you've made and that you've given evidence about. And, this is done, keep in mind, because cross-examination is often one of the most critical parts of a challenger's evidence, of someone who's trying to challenge the will. The drafting lawyer is expected to be that sole individual with the best information concerning the deceased's testamentary instructions, and for good reason. You're the lawyer, you're the one who took the instructions to prepare the will. So of course, it is common that you would have the best firsthand knowledge. And to that end, you're going to have information that is key for the challenger to, again, apply the Banks and Goodfellow test that the deceased lacked testamentary capacity. And while the challenger might also be relying on an expert report, that expert report, which we commonly refer to as a retrospective capacity assessment, so yes, it will look at medical records and it will consider, based on those medical records, whether it is likely or not that the deceased had cognitive abilities or the capacity to sign a will at the time that it was signed, or to give instructions to their lawyer at the time they did that. But that may not be the most critical piece of evidence. It may be that the contemporaneous notes that the drafting lawyer took and the evidence that the lawyer took, the firsthand evidence that the lawyer has when meeting with that client, will be more persuasive. And so for that reason, cross-examinations attacking the steps taken in those meetings are often incredibly important. It's also important because, again, keep in mind, there's Section 13 of Ontario's Evidence Act says that you can't just claim an interest in someone's estate based on your own testimony. You need something that is corroborating and material to support your allegations that you should be entitled to something more from the estate. And that applies to will challenges. So they're going to be relying during this cross-examination, they're going to be relying on your evidence and the admissions that they hope to secure to support their argument that last will and testament is invalid. So the drafting lawyer really needs to be cautious about the cross-examiner's attempts to attack their credibility. Often, in the background, there's always this concern that the drafting lawyer's reputational risk will be hurt. These trials are often reflected in reported or published decisions that will be available for everyone to see and likely won't go away. Although they might be significantly diminished if there's a successful appeal, they still exist. And so you always have to be cautious of that. To the extent that the drafting lawyer's testimony deviates from the evidence that they gave during their discoveries, during the examination they had in that boardroom, the cross-examining lawyer may try to impeach the drafting lawyer's credibility. They may try to use those prior inconsistent statements to suggest that the drafting lawyer's evidence is entirely unreliable and ought to be dismissed or given no weight at trial. Further, if the drafting lawyer didn't take sufficient notes or follow a reasonable process, then the cross-examining lawyer is going to attack that. And they're also going to attack the drafting lawyer's observations and abilities to give evidence about anything that's not reflected in those notes. Once your cross-examination is done, you can breathe a sigh of relief. It will now be the re-examination portion, which I think Greg sufficiently covered. Again, to emphasize what Greg said, if there's a question being asked on re-examination, it is likely because you said something that does not help your case or that requires further explanation because the soundbite that you gave is problematic. And so you need to take some time before you answer the question to really think about why you're being asked that question. And that can be a challenge because, again, these are non-leading questions that are going to be asked of you. They're not going to, the lawyer for the propounder of the will isn't going to be able to take you to that specific, to get you to the answer that you want to by asking leading questions. They're going to have to ask a much more open-ended question. And so it's critical that you prepare yourselves in advance of the examination of trial. But I say that really more so is prepare yourselves in advance of your examination. I mean, it's easy to say prepare yourself, take copious notes prior to drafting the will and while getting instructions, of course. But once you're in this litigation and once there may be gaps in those records, it's really critical that you prepare yourself prior to your examination out of court, because you need to make sure that your memory is as good as it's going to be, and that you are well prepared to give evidence that favors the propounder's position. Because once you get to trial, the last thing you want to do is have to make prior inconsistent statements that will now support the propounder's position that didn't during that examination, because as Greg mentioned, that is going to hurt your credibility and you're likely going to be impeached. Okay, so that part, that is typically the examination part. The only other thing I would say is, we've talked a bit about the request to admit. We have talked a little bit about the agreed statement of facts. Again, that is evidence that you should be aware of prior to coming into the trial, and you should be familiar with it. The other thing is, again, expert reports. I think it's a good idea to review expert reports. It's not your position, and when I say expert reports, I mean retrospective capacity assessments. It's certainly not your position to be giving evidence, medical opinion to rebut the retrospective capacity assessment for the challenger. But you may be asked questions about some of the findings in those expert reports as they relate to the instructions that you receive from your client. So it's good to be familiar with that. It's good to know the lay of the land really prior to giving your testimony, because that will help you prepare to be more familiar about what you need to be rebutting when you give testimony. Also keep in mind that those expert reports will often be informed by the evidence that you've given through your contemporaneous notes. Experts conducting retrospective capacity assessments will often insist that they receive the solicitor's file before providing an opinion, because they want to know. They want to know what records were taken. They want to know whether the deceased was familiar with the scope of their assets and whether those are reflected in the notes. And you can expect that when you give evidence on that, that is going to hopefully support the expert's position, the expert for the propounder. And the last thing you want to do is deviate from the notes that you took that at the time supported the retrospective capacity assessment, because it would then put into doubt the credibility of that assessment if you then start saying other things that are contradicting from the testamentary notes that you took. We've got about 10 minutes left. I think I'll end my part here, but I'm happy to open the floor to questions that anyone might have. Again, feel free to put those in the chat. I'm usually the one hosting, not today because I'm giving a presentation. So feel free to, Maddie, you can let me know, or David, you can let me know if there are some questions that people have raised. And if you haven't written anything, you're welcome to just chime in orally. That's fine too.
Thank you, Peter. So folks, if you have a question, feel free to either unmute yourself and ask it, or if you'd like to put the question into the chat bar, I'll read it out, or perhaps one of the presenters will read it out and deal with it. So over to you.
Perhaps as we're waiting for questions, I'll just comment on one of the things that Peter said. The will drafting lawyer doesn't want to come across at trial as overly partisan, trying to protect their position. They need to be able to explain that they did their job. And it's not expected that a will drafting lawyer is going to be an expert on geriatric psychiatry or on medical issues that will affect a testator's ability to have capacity. So the most important thing is, don't try to come off like you are in the propounder's court, so to speak. You are there to justify your work, your professionalism, your competence, and to give evidence about what you did and what you observed. So that I just thought was important to put out there.
Thanks, Greg. There is one question in the chat bar I'd like to read out. Can the drafting lawyer charge for their time in attending the trial as a witness and preparing for trial?
So I'm happy to give my 2 cents into that, and Greg, feel free to add anything that you think would be helpful. Often when a drafting lawyer is being examined. They're being examined out of court, not at the trial. A term of that is that the cost of preparing the file and the cost of attending examinations, they're going to be compensated up to a certain amount. That's often something that is negotiated with LawPro. And that may be the case at trial, although, again, there is the summons to witness that provides you with a very, very modest stipend. It will not be enough to cover your billable hours by any stretch. And so if you want to be compensated, I would say that that would be up to LawPro to chime in and say that, you know, perhaps when an order is being taken out, converting an application to an action, or better yet, if the application is, if there is a direction that certain issues in the application be tried, I would say that might be a good opportunity for LawPro to chime in and say, you know, this person is going to be examined, my client's going to be examined, and they are going to be, you know, compensated for their prep and for their time attending the trial, and to specify the amounts that they are to receive. Greg, I don't know if you've got anything to add to that.
I suppose it isn't impossible to get an order allowing for compensation for a lawyer at trial, a witness at trial, but I wouldn't agree to it. If I was the lawyer acting for the challenger, you know, when you're attending a trial, that is a legal obligation that stems from, you know, being served with a summons to witness and your professional obligations. So, you know, whether you want to get paid isn't really the issue. If you're served with a summons, you show up, and you know, you have to answer questions about the work that you did. That's part of the cost of doing business. But if you want to take a shot at it, you know, you can.
I see another question in here. What are the differences between the drafting lawyer's assessment of capacity versus the retrospective report? It's a good question.
Before you answer, Peter, I'd like to make an advert for the person that's asking the question.
Okay.
The question comes from Dr. Elizabeth Moore, who, if you don't know Dr. Moore, she is a clinical psychologist, a designated capacity assessor, and has a deep understanding of the law in this area, as well as a great deal of experience. And for those of you that are considering retaining an expert, I would commend Dr. Moore to you. Go ahead, Peter.
Well, it's good to lay that out. I take it this question is more for informational purposes for the group than as opposed to just Dr. Moore herself. It sounds like she's more than capable to know this answer, but I'll do my best. The drafting lawyer's assessment of capacity is something that's typically done at the meeting with the deceased. They are again, hopefully applying the Banks and Goodfellow test to consider whether the deceased understands their property, their assets, whether they understand the reasons for why they want to make certain changes to their will. You know, appreciating the significant differences to prior wills, maybe appreciating that they are removing close family members from their will. And from that, contemporaneous notes will hopefully be taken to you know, write any explanations that are necessary, and to come to the conclusion that the deceased at that time, not the deceased, the living person then, appears to have capacity to prepare a will. That's different from a retrospective capacity assessment, which will be the documents that they're relying on will be far more encompassing. Often they will be certainly looking at the medical reports that by that point are normally produced through court order. They will be looking at records from OHIP to see the history of the deceased's attendance at medical facilities. Certainly they'll be looking at any lawyer, or rather doctor's notes regarding any decrease in cognitive ability. They will consider the medication that the deceased is taking or was taking at the time that they prepared the will, to determine whether that inhibited their ability to know what they were signing or know what they were instructing. So as from a documentary standpoint, the assessment is far more in depth, and it's far more analytical in that way. But that is not necessarily to say that it is what will win the day in the end, because a retrospective capacity assessment is just that. It's retrospective. The medical expert doesn't have the benefit of being able to interview the deceased. The lawyer, on the other hand, did have that ability. And so it may be that a judge in the end favors the lawyer's, likely much less analytical assessment or less in-depth assessment of capacity, because of the fact that it is contemporaneous.
I would
Thank
just
you
add
very
that-
much. Greg, I'm sorry, did you want to weigh in?
Yeah, I was just going to add that in most circumstances, the lawyer preparing a will is not going to have access to any kind of detailed medical records. If the lawyer is advised that there are issues with the testator's capacity, then they would be well advised to go into more depth in getting information about the medical condition of their client. And it might get to the point where they are concerned enough that they say, you know what, I need an assessment, a medical assessment, capacity assessment before I prepare this will. But at the end of the day, a lawyer is not an expert on this topic. What they have to do is understand the standard of practice that is expected of them and to ask the right questions so that red flags will be noted, and then that will be recorded in the records. And if there are enough red flags, that lawyer can request more information or an actual assessment report, or their records at least will reflect that there were some potential concerns.
Thank you, Greg. I note that it is 1 o'clock and that we're out of time. I would like to remind people that in the chat bar, you will find a certificate of attendance that you can download for CPD requirements. I'd also like to remind you that there is a link in the chat bar to the B'nai B'rith Canada Food Program, in case you would like to donate to this cause, which we encourage you to do. And I'd like to thank you for attending today. My apologies that there isn't time for further questions. However, if you would like to ask a question of either of our speakers, I would encourage you to write to them directly, and their email contact details is available on our webpage. So thank you very much, everybody. And I hope you will attend the next series of seminars that we will make available when the details are known. Thank you very much.
Thanks, David. Again, thank you to everyone who has attended these series. I know it's been a long haul. It's been much appreciated, though. And like David said, we look forward to sending you information about next year with the series that we end up preparing for you. So thank you again very much. Best wishes to everyone.
And thank you, Peter and David, for moderating these seminars. And Maddie, thank you so much for all of your hard work. All right, take care, everybody.
Have a nice day all.